Bright Tuty. Every student matters.
Hello students, I'm once again here with you with Fundamental Rights, Duties and Directive Principles of State Policy, chapter number 11. All about this chapter is meaning of the significance of rights, fundamental rights in the Indian Constitution, right to equality, freedom against exploitation, freedom of religion, cultural and educational rights, right to constitutional remedies, directive principles of state policy, and then justifiable rights, classification of the directive principles, implementation of the directive principles, fundamental duties, relationship between fundamental rights and directive principles. In simple words, rights are the common claims of people which every civilized society regards as essential claims for their development and which are therefore enforced by the state. And rights are those conditions of social life without which no man can seek, in general, be himself at his best. The fundamental rights were included in the constitutional way. Why? Because they were considered essential for the development. And fundamental rights are a group of rights that have been recognized by the Supreme Court as requiring a high degree of protection from the government encroachment. These rights are specifically identified in the Constitution, especially in the Bills of Rights, or have been found under due process. Now, all people, irrespective of race, religion, caste, or sex, have been given the rights to move to the Supreme Court or the High Courts for the enforcement of their fundamental rights. And if it is not necessary that the aggrieved party to be want to do so, poverty-stricken people may have the means to do so, and before, in the public interest, anyone can commence litigation in the court on their behalf. Fundamental rights are exactly required by all the citizens of the country, and if I talk about the bills of the right as well, a democracy must ensure the individual have certain rights that the government will always recognize these rights, and therefore it is often practiced in most democratic countries. And main objective of inclusion of the Bill of Rights in the Constitution is to secure that certain values of the Indian citizens which are very essential for a free society. Other important objective behind inclusion of these fundamental rights in the Constitution is establishment of a law-abiding state and is a government of law and not of men. Now, why fundamental rights are significant? Now, what is the significance of the fundamental rights? Like bedrock of democratic system in India, obviously, this is the base of democracy, because when people have fundamental rights, then only they would feel secured and even they would choose their own representative with free mind. Provides materials and more protection to human beings, because as I said, it is the secured feeling. When people have fundamental rights, you get very much security in your own country. Otherwise, you will not feel free and the sense of belongingness will not be there. Formidable bulwark of individual liberty and established rule of law in the country. Why law is established? Law is established because when the people have the rights, on the other part, they must feel their duties as well. Because when they would have to follow the laws, then the country would be in the discipline as well, and protect minorities and weaker sections. And this is the special privilege given in the Constitution. The people, those who were not feeling secured in the country, like the minorities and the weaker section, they were provided with the special provisions so that they should have strong sense of feeling here in the country. Strengthen secular fabric of Indian state. All religions are equally treated. No special status to anyone. Check the absoluteness of the authority of the government and foundation of social equality and social justice. And the government is also accountable to the people, and each and every person will be treated equally, and each and every person of India has the equal rights, and if he or she commits any crime, equal justice or punishment is there. Ensure dignity and respect of the individuals, and our constitution, our fundamental rights, they always ensure the dignity and the respect of one person and facilitate participation of people in political and administration as well. Now, rights help in establishing relations between city and states because it implies a relationship among the citizens. And between the state and all citizenship confers various benefits, and including the right to enjoy a nationality, and the nature of the political settlement can greatly impact and the political statement, society relations often have little incentive to engage with citizens and to build up effective public also. And the right of publicity, sometimes referred to as personality rights, the right of an individual to control the commercial use of one's identity, such as name, image, likeness, or other unequivocal identifiers. And even the civil liberties and democracies, through the scope of the term, differs between the countries, and civil liberties may include the freedom of conscience, freedom of press, freedom of religion, freedom of expression, freedom of assembly, the right of security, and liberty, freedom of speech, the right to privacy, the right to equal treatment under the law and due. Then there are the rights check on the arbitrary powers and the acts of the government. That means the fundamental rights primarily protect individuals from any arbitrary state sections. But some rights are enforceable against individuals. These provisions act as a check both on state action as well as the action of private individuals. Rights are a check on certain actions of private citizens and organizations. It ensures a democratic system in which all persons enjoy certain rights. In this chapter, by another person or private organization, such a government, executive, as well as legislative actions can be declared. Rights preserve and protect interest of minorities, and Article 29 protects the interest of the minorities by making a provision that any citizen section of citizens having a distinct language, script, or culture have the right to conserve the same. And Article 29 mandate that no discrimination would be done on the ground of religion, race, caste, language, or any of them. Fundamental rights available to both citizens and foreigners except enemy aliens. And Article 14 equality before the law and equal protection of laws. And Article 20 protection in respect of conviction for offences. And Article right to elementary education. The children, those who are 14, they all have the right to get free education in the country. Then rights are enforceable by the courts. Like the Supreme Court has the final word or the interpretation of the Constitution and its orders, and being law are binding and enforceable by all authorities, executive, legislative, and judicial. The Universal Declaration of Human Rights. It says that everyone has the right to an effective remedy by the competent national tribunals for acts violating the fundamental rights granted to him by the Constitution or by law. And Indian Constitution adopts the rights in this form. The right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by the part is guaranteed. Now let's read about the fundamental rights of Indian citizens. Now know your fundamental rights like right to equality, right to freedom, right against exploitation, right to freedom of religion, right to cultural and education, and right to constitutional remedies. But first of all, what are fundamental rights? As we have already discussed, these are the claims which a person gets from the country, and it gives a sense of security. So let's start from the right to equality. Equality means all equal, the equal treatment of everyone before the law. And Indian Constitution provides the state not deny to any person equality before the law. And it prevents the discrimination on the various grounds and treats everybody as equals in matters of public employment, and abolishes untouchability and titles such as the Sir, Rai Bahadur, etc., etc., etc. Now, right to equality before law, Article 14, prohibition of discrimination, equality of opportunity in matters of public employment, Article number 16, and abolition of untouchability, Article number 17. Now, equality before law. Equality before law also includes equal opportunity under equal conditions to all, and that is there shall be neither any class of particular rights nor any particular class shall be deprived of a particular right, and the laws made by state shall be equally applicable on all the citizens. And as a concept of it is originated in England and is considered to be negative in nature, it is based the maximum no man is above law, and all individuals, irrespective of their social standing, are subjected to the same law of the land. Prohibition of the discrimination on the certain grounds, like on the basis of any grounds only of religion, race, caste, sex, place of birth, or any within them, and a citizen cannot be denied access to shops or public restaurants or use of public wells, tanks, bathing ghats, roads, and places of public resort, because it is the establishment of the social equality, and Indian Constitution establishes social equality and economically equality. Two exceptions have been made on this constitution. First, the state has the right to make special provisions for women and children, and second, there can be no limitation on the state when it provides the special arrangement for the upliftment of backward classes and scheduled caste and scheduled tribes. Equality of opportunity in matters of public employment. Article 16 provides that equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. And this also provides no citizen shall, on grounds only of religion, race, caste, sex, descent, place of birth, residence, or any of them be eligible for or discriminated against in respect of any employment or office under the state. And the exception cases, like first, nothing can prevent Parliament from making any law prescribing in regard to class or class employment and or appointment to an office under the government of any uh, requirement as to residence within that state or union territory prior to such employment or appointment. And reservation for backward classes, like besides scheduled caste and scheduled tribes, a large segment of our society is still backward. So from time immemorial, a demand has been raised for these reservations, and considering a lot on all the aspects of these issues, Mandal Commission was formed, and this commission recommended, along with various kinds of recommendation, that is fair to provide the benefits of reservation to these castes up to 27%. And though in many states they were already enjoying the benefits of the reservation, still there were a lot of agitation on the issue for as the government services were concerned. And finally, the government approved 27% reservation in August 1990. Evolution of untouchability. According to Article number 17, untouchability is abolished and its practice in any form is forbidden, and the enforcement of disability arising out of untouchability shall be an offence punishable. And in accordance with law, the most condemnable evil custom of untouchability of the Indian society was legally put to an end forever by this article. And under this fundamental rights, the Indian Parliament passed the Abolition of Untouchability Act 1955, and its practice in any form is forbidden. And Article 17 deals with abolition of untouchability. It states it is abolished and its practice in any form is forbidden, and the enforcement of any disability arising shall be an offence punishable in accordance with law. And there are few things which government can do in this regard: reservation in government services, and right to education in government schools and colleges, and special arrangements for education also. And one more thing was there, like abolition of titles. No title and not being military or academic distinction shall be conferred by the state, and conferring title leads to inequality. British government always try to its level best to prepare the people of the country to become anti-national, and conferred the titles of Rai Sahib, Rai Bahadur, Khan Bahadur, Sir Sahab. Such persons recited in appreciation of their masters, and at the time of non-cooperation movement, people give it back to them. The right to freedom. The right to freedom is one of the fundamental rights guaranteed by the Constitution of India, and the right to freedom gives citizens basic freedom with respect to speech and expression, form associations, freedom of personal liberty, and freedom to live a life of dignity. Right to freedom is under Article 1922, certain rights regarding freedom of speech and expression, right to life and personal liberty, right to education, and protection against arrest and detention in certain cases, preventive detention, effects of a proclamation of emergency on fundamental rights, and restriction on rights. Right to freedom, freedom or liberty are the two rights that are most essential to a democracy, and it is not possible to think of the one without thinking of the other. And liberty means freedom of thought, expression, and action. However, it doesn't mean that freedom to do anything that one desire, and expressions and action. However, it does not mean freedom to do anything that one desires or likes. Therefore, freedom are defined in such a way that therefore, like freedom without threatening freedom of others, without endangering the laws and situation, and the rights providing on Article number 19 are made available only the Indian citizens. And the six freedoms are freedom of speech and expression, freedom of assembly, from association, movement, residence and settlement, and freedom of profession, occupation, trade and business. And Article 20 gives the protection respect of conviction of for offences, protection of life and personality liberty. Article number 21 and 22 gives protection against arrest and detention in certain cases. Certain rights regarding freedom of speech and expression are all the fundamental rights are enshrined in Part 3 of the Constitution of India. And the right of freedom of speech and expression implies that every citizen has a right to express his views, opinions, belief, and convictions freely by mouth. And here, the person can have the right to information also. Right to information, however, was introduced in the Parliament as Freedom of Information Bill as well. The rights of persons accused of any offense. In case the person is accused, he has a right to be protected against any illegal and arbitrary arrest by a law enforcement body. Police authorities have wide powers granted under criminal law to arrest and investigate the accused person charged under the congeniable offense, placing him before the magistrate. And every person has the right to life and personal liberty as well. And life to personal liberty entitles to live their life on their own terms, on their own way, to unfair interference from others. Article 21 of this part states that no person shall be deprived of his life or personal liberty except according to the procedure established by the law. And this is known as right to life and personal liberty. And right to privacy is also there. Like right to privacy is a fundamental right and an intrinsic part of Article number 21 that protects life and liberty, in which as a part of freedom guaranteed by Part 3 of the Constitution in June 2011. And India passed a new privacy package that included various new rules that apply to companies and consumers as well. A key aspect of the new rules and required from the data subjects before undertaking certain activities. Application of the rule is still uncertain, and the Aadhaar card privacy issue became controversial when the case reached Supreme Court. Right to Education Act. The Constitution 86th Amendment Act 2002 inserted in Constitution of India provide free education to each and every child of age group from 6 to 14 years, and as a fundamental in such a manner as the state may by law or determine. Protection against the arrest and detention in certain cases, Article 22. Constitution of India, protection against arrest and detention in certain cases. No person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. Preventive detention. Preventive detention means to detain a person so that to prevent that person from the commenting on any possible crime, or in other words, we say by the administration on the grounds of the suspicion that some wrong actions may be done by the person concerned, which will be prejudicial to the state. Like a person so detained cannot be detained for longer period than 3 months without the recommendation of an advisory board. And if sufficient cause for such detention exists from the government side, it can detain even beyond 3 months. And if the advice of the advisory board is contrary, then the person will have to immediately released. And it is a duty of the detaining authority to make the detained known uh, the cause for the detention as early as possible. And the government should afford the defense the earliest opportunity to make the representation. Effects of proclamation of emergency on fundamental rights. The Constitution of India provides three types of emergencies: national emergency, Article 352, state emergency, Article 356, and financial emergency, Article 360. National emergency can be declared due to war, external aggression, or armed rebellion. State emergency can be declared due to the failure of the constitutional machinery in states, and financial machinery can be declared due to the financial stability or credit of India or part of the territory is threatened. Now, the restrictions on the rights. An act to provide for the restriction of the certain rights conferred by Part 3 of the Constitution in their application to the members of the forces charged with the maintenance of public order so as to ensure the proper discharge of their duties and the maintenance of discipline among them. The right against exploitation. and right against exploitation. Like in the medieval India, zamindars, kings, and nawabs, and people belonging to higher classes, the rich class, the upper class, they took forced labor for the people, and belonging to lower classes, they gave nothing in return for their private services. And another closely related for the exploitation was buying and selling of human beings and using them as slaves. Right against exploitation is under Article number 23 and 24, prohibition of traffic in human beings and forced labor, and prohibition of employment in children in factories. Traffic in human beings is prohibited. The past 1,000 years of slavery gave birth to evil customs in Indian society, and it also includes the sale and purchase of women and children. This article prohibits this method of exploitation, and thus the sale and purchase of women, children, and men are prohibited in India, and it also includes the prohibition of traffic in women and children for immemorable and other purposes. Beggar and etc. The bonded labor are also prohibited. The article prohibits the custom of beggar and other similar forms of forced labor, and this means none can be forced to work without wages, and none can be forced to perform a labor against his desire. It is a legal offense. And there is a limitation even on this right. Nothing shall prevent the state from imposing compulsory service for public purposes, and in imposing such service, the state shall not make any discrimination on grounds only of religion, race, caste, or class on any of them. And the prohibition of employment children in factories. The owners of factories, mines, etc., like to employ minor children because they are cheap or engaged in any other hazardous employment. And in the interest of health and strength of young persons, by prohibiting exploitation, the Constitution has opened the way for the progress of the posterity. Right to freedom of religion. Article 25 gives every person the right to freedom of conscience and the right to freely profess, practice, and propagate religion subject to public order, morality, and health. Article 26 also gives all dominion and the right to manage their own affairs in matters of religion. Like freedom of conscience and free profession, practice, and propagation of religion. According to this right, subject to public order, morality, and health, all persons are equally entitled to freedom of conscience and has the right to freely profess, practice, and propagate the religion. Then freedom to manage religion affairs, subject to public order, morality, and health. Every religious denomination or any section thereof shall have the right to establish and maintain institutions for religion and for their charitable purposes, also to manage its own affairs, and in matters of religion to own and acquire movable and immovable property, and to administer such property in accordance with law. And freedom as to attendance at religious and educational institutions as well, and freedom to payment for promotion of any particular religion is also there. Our constitution prohibits the levying of a tax, the proceeding of which are the meant specifically for payment of expenses for the promotion of the maintenance of any particular religion or religious denomination. Law in Indian Constitution. The preamble of the Indian Constitution has the word secular in the Article 25 to 28, implying that the state will not discriminate, patronize, or meddle in the profession of any religion. However, it shields individual religions or groups by adding religious rights as fundamental rights. India has been declared as secular state because no special status is given to any of the religions. No special status is given. Article 27 gives us the freedom as to payment of taxes or promotion of any particular religion. No person shall be compelled to pay any taxes, the proceeds of which specifically appropriated in payment of expenses for the promotion or maintenance of any particular religion or religious denomination. Cultural and educational rights. Right to Education Act is an act of the Parliament of India which describes modalities of the importance of free and compulsory education for children between 6 and 14 years. And above all, India is a vast country, and cultural of the people too is wide and varied. They are from diverse cultures, and a person having looked back far off may find these basic differences and the specialities of in Indian culture to find unity in diversity. And we have different languages, scripts, and cultures, which comes under 29 article. Any section of the citizen residing in the territory of India or any part of thereof having a distinct language, script, and culture of its own shall have the right to conserve the same, and it aimed to secure the cultural and educational rights of the minorities. Like under this protection of interest of minorities comes, and the right to admission in the state maintained educational institution is also there. It provides that no citizen shall be denied admission into any educational institution maintained by the state or receiving old and aid and state funds on grounds only of religion, race, caste, or language. And right of minorities to establish and administer educational institutions. This article provides all minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice, but the state, while granting an aid, shall not discriminate. And compensation on acquisition of property of minority with the 44th Constitution Amendment Act 1978, right to property was removed. Article 30, the Indian Constitution states the right of minority to establish the administer educational institution. It says all minorities, whether based on religion or language, shall have the right to establish and administer educational institution of their choice. Rights to constitutional remedies. Now, if the Constitution have not provided a device to safeguard the rights to our mentioned rights must have lost their importance. In the absence of the system, the state could have put hurdle in the promotion of these rights. And because of these constitutional remedies, if the state tries to deprive any one of these basic rights, then the individual can seek its protection. Through the Supreme Court, the Constitution has entrusted the task and of protecting the fundamental rights. And to the Supreme Court and the High Courts, these courts provide protection against writs and orders are explained here. The very first is your writ of habeas corpus. It is derived from the Latin letters have the body, and this empowers the court to issue orders for the production of a arrested person before him who is detained, and if the person move the court against the detention is unlawful, and then he or any of his representative can move the court against his detention, and if the court finds merit in the application, it may issue the writ on the detainer and ask the detained to be presented before him, and if the court feels that the detention has no merit, and then it can order the release of the person so detained. This writ, in fact, prevents the executive from becoming absolute. So that means the first one is your writ of habeas corpus. Next is your mandamus, writ of mandamus. And the Latin word mandamus, that means we command. And if an individual and institution fails in performing its duty, the court orders to perform the duty by issue of the writ of mandamus, and it is a lawful degree is denied to a student and by the university, then the farmers approach and the court may issue the writ to university in order to issue the degree. Then writ of prohibition. A writ of prohibition is issued to prevent an inferior court from exercising powers with which is against the procedure of the law, and then the High Court or the Supreme Court can prohibit the lower court from doing such a kind of prohibition order issued by a higher court or to a lower court is writ of prohibition. Writ of quo warranto. It means by what authority. If a person has occupied an office and that is too wrongfully, so by contesting to the office, a court may issue this writ against the person who is unlawfully occupying the office. For example, if I say, if a person keeps occupying the office even after the expiry of the tenure, the interested person can move the court and the later finding merit in the application may issue this writ against the person who unlawfully holds the office. Then next is your writ of certiorari. It means be more fully informed. The judiciary function as the protector of rights as well, because since the very beginning of the constitution, judiciary has served as the main protector of our rights. And detention of persons under MISA, Maintenance of Internal Security Act, that is TADA, also Terrorist and Disruptive Activities Act, has been upheld by the Supreme Court. And at the same time, the Supreme Court and the High Court warned such laws could gravely damage one's personal liberty, and therefore they should be used sprangly in as few situations as possible in 2006. And the Supreme Court directed the states of Gujarat, Maharashtra, and Madhya Pradesh to provide proper relief to the tribals and cultivators who had been displaced because of the Sardar Sarovar project. Jyotiba Phule, born in 1827 to 1890, was born in Satara district of Maharashtra and respectfully addressed as Mahatma Jyotiba, was highly admired social reformer. His book Gulamgiri focused on poverty and hardships which the lower classes were then facing. He conceived of a society based on justice and liberty and equality. The Constitution of India guaranteed us the fundamental rights, the enjoyment of which was made possible by the sacrifice and suffering of very many persons.